Hey, welcome back to another episode of Seven Figure Music School. Today we have a special guest. It is Stephanie Maris, who is an attorney that I've worked with in the past. And today we're going to ask the question, what's a realistic non-compete that a music school can use with their teachers and their staff? Of course, we're going to dive into this a little bit deeper. Before we answer that question, though, Stephanie, I'd love to, I kind of gave a little bit of an introduction there, but tell us a little bit about yourself and background, and maybe that's a good way to get started here.
Thanks, Daniel. I appreciate that. As Daniel mentioned, my name is Stephanie Maris. I'm an attorney in Indianapolis, Indiana. I work at Cohen, Garlick & Glazier, and I mainly work with entrepreneurs and business owners to help them grow their business through different business models, mainly licensing and franchising. Part of what that entails is also working with them in protecting their intellectual property, which can include trademarks, copyrights, and their business itself, the trade secrets. Yeah. So I'm happy to be here and looking forward to providing some information.
Very, very cool. And that's those specialties that you kind of mentioned there are exactly why we initially got connected. And speaking of those specialties, I think a good question to start out with is around a question that I see quite a bit in conversation that smaller schools, mid-sized schools have, larger schools have, and that is around the topic of a non-compete agreement. So there's, at least on a monthly basis, I see this argument happening on Facebook in the various music school support groups. At least a month. Someone comes in, they don't use the search function, they put this question there. Hey, I'm in a non-compete agreement. And my employer, I'm a teacher, and my employer is saying that I can't teach within 20 miles of the school that I've been teaching in the last 2 years now that I want to go independent. And then there's the flip side of the coin, a music school that they don't want a teacher leaving the school and taking students with them, students that they work very hard to market for and enroll at their school. And so they want to assign those teachers to a non-compete and prevent them from, stealing students. But in some cases, those schools don't even want them working in the local area. So I actually want to dive really deep and see what's true, what's legal. As usual, everybody has their degree from the University of Facebook. And in this particular case, it's around this non-compete thing. So that's the question I have for you today, Stephanie. So based on what I've heard so far, I know this is a little bit open-ended. Maybe you could give us the broad strokes of what a properly drafted non-compete can actually do or not do.
Right. Well, I think to start off, it would be really helpful if I provide a definition of non-compete, because people use that term very broadly. And there's actually different types of restrictive covenants. And you mentioned two different types in your question there. One is a non-compete in the traditional sense, where somebody is prohibited from competing within a defined geographic area, which is usually centered around, in this case, what would be the music studio, or there are non-solicitation provisions. And that would be similar to preventing somebody from providing services or soliciting clients that they worked with while they were employed at the studio. And so people typically lump all this together under the term non-compete, when in reality, they're restrictive covenants. And so some NDAs, non-disclosure agreements and non-compete agreements will have a geographic restriction. Some will have a non-solicitation restriction, and many will have both. So it's important to distinguish between those and to look through those, or look through your contract to see what it says. In terms of, determining the enforceability or the properness, to use your words, Daniel, of the non-compete, it is important to consult an attorney. Non-competes and restrictive covenants are not federally regulated, and they're actually different on a state-by-state basis. So, for example, myself, I'm licensed in Indiana. And so from an Indiana perspective, a non-compete has to be reasonable in three elements. the scope of the non-compete, the time frame of the non-compete, so how long it is, and the geographic location, if there is one. Now, these elements are similar across the country, but they're not defined the same way in some instances, and some states have different types of restrictions. And then some states go even further and actually prohibit these types of restrictions in agreements for employees, and they're only available in the sale of a business. And so it is important that you consult a local attorney either before drafting a non-compete or before entering into one, so that they can advise you as to whether it is going to be enforceable in your jurisdiction.
Okay. So Nate, I can already tell you have a lot of questions there, but I just want to ask a really basic one before you jump in, Nate. I have heard, and again, this is the University of Facebook type stuff, like, they can't tell you that you can't teach within 5 miles of the studio. Like that it's only enforceable as much as they actually want to take you to a court of law to do that. I'm curious how you would respond to something like that. Okay, and if I'm being too simplistic, jump in and push back, because this is the conversation in our industry. And so I'm merely repeating what I see, but you would be like, oh man, how do I even start with this guy? But so I'd love to hear what you're thinking.
So technically, until somebody tries to enforce a provision in your contract, you could, sure, go compete within that 5 mile radius. You're obviously putting yourself at risk for being in breach of the agreement that you signed, which could result in damages and that kind of thing. But one other item I didn't mention earlier is that a non-compete has to be, or a restrictive covenant has to be, tied to a legitimate business interest. And so in the case of a music studio, it would, restricting somebody from teaching within a 5 mile radius would, in many instances, likely be closely tied to the legitimate business interest of the studio. And so there's not a blanket, you can't do that unless you're in a jurisdiction in which non-competes are not enforceable at all. So again, as I said, I'm licensed in Indiana. So in Indiana, that would be a permissible restriction to prevent somebody from teaching within 5 miles of the studio. So long as the rest of the non-compete is within, reasonable bounds.
Wow.
So can I jump in here for a second? Because I so appreciate having your expertise here. And I feel like in the 12 years that we've had Brooklyn Music Factory, I've had, our first attorney was the parent of a longtime student at our program. And then we've had a couple of other over the years, right? And one of the real challenges is actually linking to sort of the reality of being a small business owner. So for example, going back to your 5 mile radius example, like we'll be in Indianapolis. There might be 20 schools within that 5 mile radius already serving students. So just to get clear, if I hired, Daniel to teach at my studio and said he could no longer teach within a 5 mile radius after leaving within, say, 2 years, does that mean, are you saying that he couldn't go get hired at the school on the same block?
If he signed the non-compete and it was within the bounds of the state interpretation of non-compete, that is correct. He would not be able to go down the street to School of Rock and get a music studio. Now you have to keep in mind that these non-competes are not forever. The non-compete would have to be reasonable in terms of time. So it more than likely would be a 2, 3, maybe even a 1 year term. So he wouldn't be prevented from working at the school down the street for forever. It would just be for the length of the non-compete.
Okay, so that's fascinating. So can we rewind tape to your 3 reasonable? I love the 3 criteria: scope, time, geographic. Let's go with what is it so in Indianapolis, for example, what would the proper, what do you think is a reasonable one that a school owner in that jurisdiction might put down? Just give us a sense. Time frame, would it be 1 year, 2 years, 6 months? And geographic, I'm curious.
So courts in the state of Indiana have frequently found that non-competes within a year range of 2 to 3 years for employees can be found reasonable. Again, this is all fact specific, so just keep that in mind when I'm providing these answers. And then the geographic scope also has to be reasonable, which can, in certain circumstances, be no more than 5 miles and can go all the way up to 20 miles, depending on the type of business and the size of the school, that kind of thing. Let me go the other way. You could not restrict, for example, the whole state of Indiana, or you could not say the United States, because the non-compete has to be tied to the legitimate business interest of the employer. And the goal is not to put an employee out of work or to prevent somebody from using their genuine skills, talents, know-how from providing for themselves. The idea is to protect the business and the employer that has put their time, effort, and money into growing their business. And so that's why it's got to be reasonable. And if I was advising an employee, if the non-compete met all the requirements of reasonability and was likely to be enforceable, their recourse for the duration of their non-compete would be to provide services outside of that geographic territory. And it may be inconvenient for 2 years, but that would be an option, because it's not like they can't go teach anywhere. They just wouldn't be able to teach within that geographic scope.
So it sounds to me, because you made a distinction early on, this is all very interesting, fascinating. I love this. What it sounds like is that most schools should actually be having their team sign a non-solicitation agreement. Because if a teacher is working for you and they're thinking to themselves, you know what, I have the values of this school, I was really on board with. I really liked their views. I really like the idea of teaching kids, rock, pop in a band setting. But you know what? My background is in classical piano. And I want to start a school that teaches kids in that domain. Now, it's still piano lessons from the outside looking in, so to speak. But this person has a real burning desire to do that. So they would maybe go, start teaching out of their home, perhaps have 20, 30 students, whereas the school they came from maybe has 200, 300, 500 students. I know we didn't have you come on for this, Stephanie. I'm just putting my opinion in here, but I don't know as a school owner if it makes sense for you to hire to do a non-compete with someone if they just want to leave and teach on their own because they want to be their own boss. So it sounds like in that case, perhaps maybe not, and this is opinion, maybe the thing really is the non-solicitation. Hey, just don't take our students. Mm-hmm. And I'm curious what your thoughts are on that, Stephanie, given kind of the scenario I laid out there.
Right. The non-solicitation that we were discussing earlier and that you just described is frequently used in businesses in which the main product or good is a service. So non-solicitations are really important in the medical industry, where patients, are the consumers, so to speak. In the music studio setting, obviously the students are very important, or in sales. Salespeople most often have a non-solicitation in terms of who they can contact. And so, yes, in this instance, if it would be, for example, too difficult to kind of figure out what that geographic scope would be, maybe you don't have a non-compete, maybe you have a non-solicitation, which would prevent the teacher from providing services to or soliciting to provide services to any student that was enrolled at the studio during the time that they were employed there. Now, with the non-solicitation, there could be some issues in terms of, well, what if the teacher never taught one of the students? So for example, at a school with 200 to 300 students, maybe Jenny was never taught by teacher Johnny, but it just so happens that his home music studio is closer to her house. It's better for her parents. Johnny had no idea that Jenny was enrolled at his former employer. You know, there may be some wiggle room in that type of scenario because he didn't solicit her. He didn't know her from before to provide, you know, music services too. So it's not as all-encompassing, I guess, as it may sound. And again, it's going to depend on what the courts and the jurisdiction have interpreted.
Stephanie, I want to zero in on that last comment there. And I think, Daniel, you hit it on the head. In my experience, you know, Stephanie, we've had a school, you know, our numbers have fluctuated, but sort of in its largest, it's served well over 1,000 students in any given year. And we instituted a non-compete. And between the three of us, what we really meant to institute was a non-solicit, because the reality is, and I bet you all the listeners here are nodding their head to this, none of us are going to court after one of our teachers. We just aren't. It's not a reality. There's not the funds in the budget. I know what an operating school budget looks like. There is not a legal line to spend both the time and dollars to try to find that teacher who took 15 guitar students, right? However, let me reframe. No, actually, let me ask you the question and then reframe Daniel's comment, because this is a very real thing that has happened at Brooklyn Music Factory. But I want to ask you one more nuance around that solicitation, because you brought up a great you brought up a nuance there, Stephanie, where you're like, okay, well, what if I never taught Jenny, but somebody else at Brooklyn Music Factory taught Jenny? Is that still a non-solicit? How about if, and this happened recently, this happened literally like a month ago at Brooklyn Music Factory, where a teacher left and then the family solicited her to continue teaching the student after, you know, a month after she had left. They were like, hey, by the way, we've now left Brooklyn Music Factory and we're soliciting you. Would you now teach our child again? What is it? What's your response to that scenario?
Well, it's going to be a typical lawyer response, because it's going to depend on how the term solicitation is defined in the restrictive covenant agreement.
Then how would you recommend that a school define that, given Nate's scenario, wanting to protect from that?
Okay, so in Nate's scenario, if you wanted to protect against families reaching out to a teacher that left, you would want to make sure in the non-solicitation that it prevented the teacher from providing services to current or former students that were enrolled at the time the person left the studio within 6 months or something to that effect. So if the parent said, hey, we were at Brooklyn Music Factory, we're no longer there, can you teach so-and-so? It would be up to the former employee, but the correct answer would say, you know, I'm really sorry, I would love to teach Jenny, but under, you know, my restrictive covenant, I'm not able to do so. Contact me again in 6 months, I guess. But the reality is that just may not be practical. And so at that point, it may be a good idea for, if the employee left on good terms, you know, to contact the employer and ask for consent to provide these services, because an employer can agree, you know, in writing that this would not be a breach of non-compete, which if a music studio has 300 students and they have a good relationship with the former teacher, you know, they'd probably be okay with that. But that would be one manner in which you could try to make sure you're not in breach of your agreement without having to turn down a client. Now, of course, if they said, nope, can't do it, then you might be a little out of luck in that scenario.
You know what's interesting?
Oh, go ahead, Nate.
Well, I'm just going to say that I love the language. I love that you share the language for the employer to use with the employee. Right. And then that's one of the key changes in how we've worked with our employees, is instead of showing them the document and being like, hey, this basically says this, sign it. We say, this is the purpose of this. And if we get to the end of your, engagement at Brooklyn Music Factory, and you do find yourself being solicited by a family for a student, what you're signing here is just asking you to use this language. And so you did anyone who's listening should absolutely write down what, Stephanie just said. Here's the language to use.
And I'll further say, anyone listening would do very, very well to actually reach out to Stephanie if they have yet to draw up documents like this. Because one of the things I've appreciated about Stephanie is that she's done a lot of legal paperwork for me. But one of the things I've loved is just being able to get on Zoom with her and ask from, client to attorney, like questions, well, explain what this does for me. And, in the same way that she kind of explained that there, for us here on the show, she's been able to do for me in a lot of different things. And I've made the joke to Stephanie before, I feel like I almost need an attorney to help understand these documents. It's like, well, that's what I'm here for. I have an unconventional question. And Stephanie, I know you're not going to like this question. I'm just going to say that. So think of a specific example, but maybe actually before I ask the question, have you ever been in litigation before, just general yes or no answer, where you've had to either enforce or do work around a non-solicit?
Yes, I do a little bit of litigation. It's not my main focus of practice, but when I do litigate, it is in the business setting and mainly involves restrictive covenants such as non-competes and non-solicits, as well as intellectual property issues.
Okay. I'm curious, given maybe Nate's scenario earlier, can you estimate what, again, I already know you're not gonna like this question. Could you even estimate what it would cost an employer such as BMF or another, fairly large school to actually enforce one of these non-solicits? If it went by the numbers and was fairly quick and easy to deal with, or maybe give me a few scenarios. I don't know. When if you want to push back, be like, well, what's this? What's this? What's this? See, I knew you wouldn't like this.
Yeah, especially when it involves disputes, it is quite difficult to say, hey, you know what? I think this is going to cost X amount, because it involves two other, parties. It involves other people. Yeah. And you don't know how the other person is going to react. In terms of cost, however, I would definitely recommend having an attorney's fee provision in the agreement, which would permit the employer to recover their costs of enforcing the agreement if they had to do so. So that's one way to get your fees paid.
It wasn't the question I asked, but it's the answer we needed. I like that. That's very helpful.
I love, Daniel, your question around like, what would it in general cost? And of course, we couldn't actually get a hard number on that. So maybe I could just ask one last question, and then we're wrapping this up because it's so good. And Stephanie, the truth is that for a lot of us as school owners, we're sort of entering this world, honestly, as musicians first, and then really passionate educators. And we had no idea when we started this business that we would come in contact with attorneys, with accountants, with CFOs, with all of these different amazing characters that actually go into the framework of operating a really successful, sustainable business. So for our listeners, they're super grateful that you're willing to just talk openly with us. So Stephanie, last question. If a teacher were to leave the school and then try to solicit a dozen of their students with over the first month that they left, what's the very first action that a school owner can take? What's the simplest first step needed?
The simplest, most cost-effective step that a school owner can take is to send an email to the teacher reminding them of their non-compete, or a letter, anything in writing, because you'll want to document it. Just reminding them of their non-compete and their non-solicitation agreement. Attach that to the email or in the letter, just so they have it. And if they disregard that notice from the employer, at that point, you would want to contact your attorney to discuss options as to how to prevent the former teacher from continuing to do this, and kind of get a game plan together with your local attorney.
Oh, I love it. Yep.
Yeah, amazing. I love the detail of put it in writing, just send an email, and then attach the signed document. They signed this non-solicit 5 years ago. Just remind them.
Yeah.
You know, that happened.
Might be all it takes. And I think to wrap, I think that once again, we're touching on a subject that if we do our homework as school owners, and we're hiring and we are process-based while we're hiring, and we have good conversations with those employees as they come in, or those contractors as they come in, and we're in a respectful way explaining to them before they sign such documents the purpose of it, and telling that in light of the vision of the school, that it might never get to that point, which I think is the example, because you lead with the heart, but if that isn't enough sometimes, then there does need to be recourse. And I think that's why we have these conversations. So Stephanie, thank you. I'd love to have you back on soon to answer another question. Maybe we could have like a monthly segment, like Ask an Attorney or something, AAA episode or something. Yes, who knows? Please. But I would say that if this is an area that your school has not yet, you've not broached these topics, or you whipped up a document in Microsoft Word thinking like, oh, this will be enough. Stephanie contact info is going to be in the notes of the show. You probably owe it to yourself, if you're serious about protecting your school, reaching out to Stephanie or someone, an aunt, an uncle who might be an attorney. But I'd recommend Stephanie because I have just had nothing but great experiences with her. Thanks so much, Stephanie. We'll see you next time.
Thank you, Stephanie.
Thank you.